Welcome back. In the previous video, we discussed the 7 major pieces of legislation that impact on an employment relationship. In this video, we will look at the BCA in more detail. The BCA has undergone augmentation over the years. It is therefore important to note that laws are updated and that as an employer, the SGB must remain abreast of all such changes. Let's take the BCA as the further example. Amended in 98, 2002, 2010, 2014, 2018 and 2020 and has direct impact on the employment conditions. Section 83A defines who is presumed to be an employee. It is a person who works for or provides services to another person and is based on the premise that A. His or her manner or hours of work are subject to control or direction. B. He or she forms part of the employer's organization. C. He or she has worked for the other person for at least 40 hours per month over the previous 3 months. D. He or she is economically dependent on the other person. E. He or she is provided with his or her tools or work equipment. Or F. He or she only works for or renders services to another person. If one of these factors is present, the person is presumed to be an employee until the employer provides or proves that he or she is not. So let's look at the particulars of employment as well as the remuneration. Please understand that all particulars relating to a contract must be done in writing. An employer must supply an employee upon commencement of employment with the following particulars in writing. A. The full name and address of the employer. B. The name and occupation of the employee or a brief description of the work. C. Various places of work. D. Date of employment. E. Ordinary hours of work and days of work. F. Wage or the rate and method of calculating. G. The rate for overtime work. H. Any other cash payments. I. Any payment in kind or value thereof. J. The frequency of remuneration. K. Any deductions. L. Leave entitlement. M. The period of notice or period of contract. N. The description of any council or sectorial determination which covers the employer's business. And O. The period of employment with the previous employer that counts towards the period of employment. Further note that under P, a list of any other documents that form part of the contract indicating a place where a copy of each may be obtained. This brings us to the keeping of records. It is important to note that every employer must keep a record containing the following information about every employee. Firstly, the employer's name and occupation, the time worked, remuneration paid, the date of birth if the employee is under 18 years of age, and any other prescribed information. As an employer, the SGB will also have to comply with the recently promulgated POPIA Act as it relates to the record keeping of personal information. We now look at information about remuneration. The following information must be given in writing when an employer is paid. 1. The employer's name and address. 2. The employee's name and occupation. 3. The period of payment. 4. Remuneration in money. 5. Any deduction made from remuneration. 6. The actual amount paid. And 7. If relevant to the calculation of the employee's remuneration, the employee's rate of remuneration and overtime rate, the number of ordinary and overtime hours worked during the period of payment, the number of hours worked on a Sunday or public holiday during that period, and if any agreement to average working time has been concluded, the total number of ordinary and overtime hours worked in the period of averaging. A written document of containing information of this nature is commonly referred to as a pay slip or wage slip. Let's now look at deductions and other acts concerning remuneration. An employer may not deduct money from an employee's remuneration unless A. The employee agrees in writing to the deduction of a specific debt. B. The deduction is made in terms of a collective agreement, law, court order, or arbitration award. Note too that a deduction in respect of damage or loss caused by the employee may only be made with agreement and after the employer has followed a fair procedure. Employers must pay deductions and employer contributions to benefit funds to those funds within 7 days. We now look at an employee's work time. Note that an employee's work time must be regulated. These stipulations do not apply to employees who work less than 24 hours a month. So in terms of ordinary hours of work, please note the following: that ordinary hours are considered 45 hours in any week, 9 hours in any day if any employee works for 5 days or less in a week, or 8 hours in any day if an employee works on more than 5 days in a week. We now look at overtime. When it comes to overtime, an employer may not require or permit an employee to work overtime except by an agreement or to work more than 10 hours overtime a week. An agreement may not require or permit an employee to work more than 12 hours on any day. Note that a collective agreement may increase overtime to 15 hours per week for up to 2 months in any period of 12 months. Overtime must be paid at 1.5 times the employee's normal wage, or an employee may agree to receive paid time off. With regard to meal intervals, note the following. An employee must have a meal interval of 60 minutes after 5 hours of work. A written agreement, though, may reduce the meal interval to 30 minutes or dispense with a meal interval for employees who work fewer than 6 hours on a particular day. With regards to pay for working on Sundays, note the following. An employee who occasionally works on a Sunday must receive double pay. Conversely, an employee who ordinarily works on a Sunday must be paid at 1.5 times the normal wage. Employees who work at night between 6 p.m. and 6 a.m. must be compensated by payment of an allowance or by a reduction of work hours, and transport must be available. Employees who work regularly after 2300 hours and before 6 a.m. in the morning the next day must be informed of any health and safety hazards and the right to undergo a medical examination. We now deal with public holidays. Note that employees must be paid the ordinary pay for any public holiday that falls on a working day. Work on a public holiday is by agreement and paid at double the rate. A public holiday may be exchanged with another day by agreement. We now look at aspects of leave. There are a number of different types of leave, the first of which is annual leave. Employees are entitled to 21 consecutive days annual leave, or by agreement, 1 day for every 17 days worked, or 1 hour for every 17 hours worked. Leave must be granted not later than 6 months after the end of the annual leave cycle. An employer must not pay an employee instead of granting leave except on termination of employment. In terms of sick leave, note the following. An employee is entitled to 6 weeks as paid sick leave in a period of 36 months. During the first 6 months, an employee is entitled to 1 day's paid sick leave for every 21 days worked. An employer may require a medical certificate before paying an employee who is absent for more than 2 consecutive days or who is frequently absent. With regards to maternity leave, note that a pregnant employee is entitled to 4 consecutive months as maternity leave. A pregnant employee or an employee nursing a child is not allowed to perform work that is hazardous to her or her child. In terms of family responsibility leave, note the following. Full-time employees are entitled to 3 days paid family responsibility leave per year on request when the employee's child is born or sick, or in the event of the death of the employee's spouse or life partner, or the employee's parent, adoptive parent, grandparent, child, adopted child, grandchild, or sibling. An employer may require reasonable proof though. This brings us to the end of this video, where we touched on the major elements impacting on a worker's conditions of employment and the contract of employment. Note that the conditions may be more favorable, but cannot be less favorable than the stipulations in the BCEA, other than when a collective agreement or sectorial determination is in place. Note too that the emphasis in this video is on workers in the employ of the SGB and not the employ of the state. To ensure that you do not miss any of our upcoming videos, please subscribe to our YouTube channel and press the notification bell to receive an alert when new videos become available. Also, feel free to leave a comment below. We will see you soon. Goodbye.